Welcome once again to Lehto's Law. Here's Steve Lehto.
Thomas sent me an interesting note last night and said, Steve, I see something's a brewing there in Michigan regarding the eavesdropping statutes. What's going on? And I was unaware of this, so I quickly took a look, and it turns out something is indeed happening with our eavesdropping statutes, or might be happening. And what I'm talking about here is, of course, the idea that in many states there are laws regarding eavesdropping. And eavesdropping is where you use some kind of mechanical device like a recording device or a microphone or something to listen in on or record conversations of other people. And the question then becomes, is it eavesdropping if you record a conversation that you're part of? So you and I are standing on a street corner talking, having a private conversation, and unbeknownst to you, I'm recording it. Is that illegal? Of course, we recognize the fact that if you and I were having a conversation and somebody was using a secret eavesdropping device from over here that we did not know about, that's a different thing. But of course, that's more likely to be eavesdropping than the part where I am recording a conversation I'm a part of. So here's the interesting thing. There's been a law on the books in Michigan for decades that talks about eavesdropping. And when you read it, depending on where you first read it, and I'll explain this in a second, it appears to say one thing. But when you go back and really dig through it, it appears to kind of say something else. And the Michigan Court of Appeals in the past has ruled that Michigan is a one-party state, meaning that if you are a party to the conversation, you can tape it without the other party's permission because it only takes one party to the conversation, and that's you. But here's the thing. That was a Michigan Court of Appeals ruling, not a Supreme Court ruling. So, federal judge questions Michigan's secret recording law, asks the Supreme Court to weigh in. The stories from the Detroit News, Beth LeBlanc wrote it. And this is actually a very similar legal action to what happened with the state Supreme Court ruling on the governor's executive orders. Okay, a federal court asked the Supreme Court for a clarification on the law. Now, a Detroit federal court judge has asked the Michigan Supreme Court to clarify whether Michigan's eavesdropping law allows an individual to record a conversation without the consent of other participants. And like I said, the Michigan Court of Appeals has said that that's legal. But the Michigan Supreme Court has never ruled on it. And until the Michigan Supreme Court rules on it, the argument can be made that it's still kind of unsettled law. The Attorney General requested the question be put to the state's high court after U.S. District Judge Linda Parker ruled in March that Michigan's law prevents any person present or not present in a private conversation from recording it without consent of all parties. So the district court judge in the federal court ruled and said, you need permission from everybody. The Michigan Court of Appeals has already ruled and says you don't. But the federal district courts are only bound by the highest court of the state. And so technically speaking, Michigan's Supreme Court has not ruled yet. Now, the ruling of the district court judge conflicts with a 1982 Court of Appeals opinion from the Michigan Court of Appeals, in which that majority ruled that eavesdropping outlined in the law only involved situations where a third party listened into or recorded a conversation unbeknownst to the participants in the conversation. Michigan has since been known as a one-party consent state, meaning anyone who is a party to a conversation could record it without knowledge of other participants in the conversation. The law largely has been understood to bar recordings by people not in the conversation, including through wiretapping or the bugging of a location. The eavesdropping case in which the Attorney General intervened to clarify state law arises from a lawsuit filed in 2017 by the American Federation of Teachers Michigan against the nonprofit project Veritas. And so apparently they had one of their undercover people record some conversations. And now the question is, was that legal? Because they did not have permission from all the parties. So when this went to federal court, which is where it's being fought out right now, the judge cited the dissent in the 1982 case and ruled that Michigan was an all-party consent state and basically said, look, I think that rationale makes more sense, and I believe if it goes to the state Supreme Court will agree with that. Now, it had never gone there yet, but it could go there now because the federal judge has raised the issue, and the Attorney General of the state of Michigan has asked the Supreme Court to render an opinion. Because of the conflict between the federal court's ruling and the 1982 majority ruling of the Court of Appeals, the Attorney General asked to have the question certified to the Michigan Supreme Court. So Michigan is the final arbiter of state law, and Michigan state criminal courts are not bound by the court's opinion, the Deputy Solicitor General wrote. Nevertheless, this court's opinion creates uncertainty about what is criminal under Michigan law. And this is confusing and important because there's a civil aspect to this statute. If you eavesdrop on me and I catch you, I can sue you for it. Likewise, I can file a criminal complaint and get you prosecuted for it. So in Michigan for the last 38 years, people have believed that this is a one-party consent state. So that means that someone out there today, for instance, might be doing something for which they could be prosecuted if the Michigan Supreme Court reverses the Court of Appeals from before. Parker granted the request this year to have the Michigan Supreme Court at least ask them to certify, to do this. So they certified the question to the Supreme Court on Wednesday. The state Supreme Court received the certified question Thursday, according to the court's spokesperson. The request to have the Michigan Supreme Court hear this certified question marks the third time in 5 years that the Michigan Supreme Court has been asked a certified question by federal judges. Like I said, they had just done this previously with respect to the executive orders. So that's the article from the Detroit News by Beth LeBlanc. Federal judge questions Michigan's secret recording law and asks Supreme Court to weigh in. And you might say, Steve, what's the confusion? Well, here's the confusion. Michigan's eavesdropping statute is found in the criminal code at MCL 750, the blue book's behind me, .539, 750.539. A and C are what we're going to talk about. So if you jump straight ahead to C, which is the eavesdropping section, it says any person who is present or who is not present during a private conversation and who willfully uses any device to eavesdrop upon the conversation without the consent of all parties thereto, or who knowingly aids, employs, or procures another person to do the same in violation of the section, is guilty of a felony. So it actually uses the phrase of all parties, without the consent of all parties. So I remember reading that when I first became a lawyer, and I said, well, it looks like it's an all-party consent state, because it uses the phrase all parties. But the Court of Appeals back in 1982 said, well, you don't look at just one section of a statute. You've got to read the whole statute and see what the whole statute says. And under 539A, which is the definitional section of the eavesdropping statute, it defines eavesdrop or eavesdropping. It defines those two words meaning to overhear, record, amplify, or transmit any part of the private discourse of others. Of others. And it says the private discourse of others without the permission of all persons engaged in the discourse. But the Court of Appeals said the phrase of others implies that the person doing the recording is not a part of the conversation. They can't be because they're not an other person. So I can see why there's confusion here. And when Thomas sent me the note, he said, Steve, are they trying to overturn black letter law? And black letter law is often a reference to the idea that there are statutes that are so clear that no one can argue what they mean. So sometimes courts will go through, mental gymnastics to try to figure out some way to interpret this to have it come out their way. But this, to me, is a confusing statute. I personally think that the correct answer is that the legislature should address this and clarify it. Because in one section where they say without the consent of all parties thereto, implies that it's an all-party consent state. But eavesdropping, which talks about dealing with the private discourse of others, implies that it's a conversation you're not a part of. And if you asked me, if you said, Steve, no one's ever ruled on this at all, are you willing to take this case up and argue this is an all-party consent law? I would. I would say it says all parties. How much more clear can you be than all parties? And of course you would say, but the discourse of others, And the question then becomes, is the discourse going both ways or is it? But I think that there's something that's ambiguous and clear in the same statute. I tend to go with the clear one, which is all parties. But the Court of Appeals has already ruled on this. And like I said, it was not a unanimous ruling because the federal district court said, we think that the dissent in 1982 is a stronger argument than the majority opinion. So I should clarify this because some people are wondering, why can a federal court ignore state law? Because it sounds like that's what they're doing, right? Well, federal courts, and I'm not going to get too heavily into this, but I mentioned this before, the Erie doctrine, E-R-I-E, like the lake. The Erie doctrine is a legal concept, and I've mentioned it a while back, that federal courts sit in states. So there are state courts in Michigan as federal courts in Michigan. And the federal courts in Michigan have their own procedures. They've got the civil procedure rules. They got the criminal procedure rules. They got the rules of evidence. They've got their own rules. When it comes to the substantive law, the actual law that they do. So for instance, let's suppose that you've got a case where someone in Michigan sues a huge corporation that's domiciled out of state for a lot of money. And that company moves the case to federal court because they think they'll get a better deal there, better shake there. The federal court will still apply Michigan law, okay, but simply use their own rules and, of course, their own judges. So when a court is asked to apply Michigan law, they go, okay, what is the law in Michigan? And the law in the state is deemed to be the law when it's been handed down by that state's Supreme Court. And if the state Supreme Court has never ruled on that law, then the court can look at other things such as Court of Appeals rulings and so on, or the court can also rule and say, here's what we think the state Supreme Court would do if they were asked this question. And I am familiar with many cases in Michigan where there was a law that had never been tested by the state Supreme Court, where the federal courts actually said, we're going to look at this and we think this is how they would rule. And then later on, the state Supreme Court ruled differently. It happens. So what's going to happen here? We don't know. That's the interesting thing. I don't know how you'd call this because this is not a terribly political question. I can't imagine that people on one end of the spectrum versus the other are saying, oh, no, we're going to go to war over this, right? There are some hot topics like that out there. I can't imagine people marching on the Capitol holding up signs going, I want the right to eavesdrop one party. I don't think that's going to happen. So I'll be curious to see what does in fact happen, because when the state Supreme Court answers the question, then it does become the law. So it might be that Michigan's been a one-party consent state for 38 years and then suddenly becomes an all-party consent state requirement. I don't know. That could happen. So I'm going to follow it. But as of right now, the eavesdropping question in Michigan is going to the state Supreme Court, and we might get a surprise out of it. I'll let you know. Questions, comments, put them below. Otherwise, talk to you later. Bye-bye.
Thank you for watching Lehto's Law. We are often more frightened than hurt, and we suffer more from imagination than from reality.